The first thing to check to prove whether the defendant has caused the crime he is accused of is to do the test for factual causation. This requires us to do the but-for test and ask whether the crime would have occurred but for the defendant's actions. In other words, whether it would have happened anyway, regardless of the defendant's act. In R v White 1910, the defendant may have wanted to kill his mother by putting poison in her drink, but she died not of poisoning, but of a heart condition, unrelated to the poison. Coincidence, yes, but crucially the defendant's act didn't cause her death, so he couldn't be guilty of her murder. Always start by considering the but-for test to make sure we can continue to establish guilt, because if the end result would have happened anyway, the defendant is not guilty. What you need to do next is to check whether there are any other reasons the defendant may not be guilty due to the actions of others. This is known as legal causation. It's basically a series of rules developed over the years by case law to make sure it's fair to find the defendant guilty. Some crimes are not so straightforward. They may involve the actions of others, such as the victims themselves, other third parties or accomplices, and even the intervening subsequent acts of doctors and hospital workers that complicate matters and lead us to examine, is the defendant really responsible for the end result?